Hello, everyone. Uh, Welcome to this second edition of our webinar that we have organized on the topic of impact of force majeure clause in the international commercial arbitration arena. So today we have with us Ms. Renu Gupta, who is an advocate based out of Delhi. So she primarily practices in matters related to commercial litigation and arbitrations. So over to you, ma'am. Let's start the discussion.
Hi, Ayush. Hi, everyone. I hope the audio from my side is working fine. Ayush, if you can just confirm that.
Perfectly fine.
Okay. All right. So I think what we're trying to talk about today is really how do we see international arbitration panning out in terms of a virtual hearing? I mean, I think we've all seen that, we've all been home for last 5 weeks now. I think a little over 5 weeks, and it's probably going to be a little longer than this, wherein we don't have access to real hearings in court, access to real arbitration hearings where we could all meet as lawyers in a sort of meeting room and do our hearing. So while that process cannot happen, I think institutions across the world have started talking about how do we function on a virtual mode in a more efficient and better way. I'm going to sort of talk about some pointers. A lot of it is what is already being discussed in the media. We have a few protocols, international protocols, which have become relevant today. There is the ICC guidance paper, which has been issued already on how to deal with a virtual hearing. There is a sole protocol on video conferencing in international arbitration. That's actually not a recent one. I think that protocol is probably a few years old, but I think it's going to be used maximum now given the current situation. So we'll try and go step by step as to what is it that can help us in a virtual hearing. What is it that we need to be prepared for? It's going to be, I think, although the topic is international commercial arbitration, I'm going to talk about issues which we're going to face even in a domestic scenario with an ICA seated in India as well as an ICA which is foreign seated. So 4 broad points, and I think those would be the scheme and the theme of my talk. 4 broad points which I see are going to become very important, more relevant than ever before as a result of virtual hearings becoming more frequent, becoming more sought after, would be number 1. I think the focus on written advocacy is going to increase. It's going to increase manifold. We've been using written advocacy in terms of written submissions, in terms of better pleadings and arbitrations for a while now. But I think we, as it happens across several institutional arbitrations, be it ICC, be it LCIA, be it SIAC, the written advocacy is more and oral advocacy is less. I think the current environment should give us that signal. I think it's already giving us that signal that the oral advocacy over the coming months, maybe a year, we don't know how much longer, is going to be reduced, and we will have to do better with better written advocacy in most cases. I think be it court or arbitration, in both we're going to be expected to put in written submissions pre-hearing, post-hearing, skeleton submissions even before a small procedural hearing. And those are the tools which are effectively going to help us manage an arbitration hearing in a more efficient, both cost-effective and time-effective manner. There are 3 more points, but I think I will cover them, in the scheme of my talk instead of probably giving them out at the outset, because then I might not be able to cover them in the manner that I've prepared. So I think some general points to start with. In the Indian context, I mean, we don't have, our statute does not recognize VC, video conferencing, or a virtual hearing, but Section 19 is broad enough to give the tribunal the power to decide and regulate its own procedure. So I think in India, wherever tribunals are, all we see and are going to use it more and more, the power to use that would be traced back to 19. Now, there is one important aspect of question, which is that as a party who wants to delay proceedings, you will come across a respondent who does not want to agree to a virtual hearing, and would a tribunal in that case pass an order for a virtual hearing without consent of parties, with actually one party objecting to it? I think those are issues which we will have clarity on over the coming few months, because it could be an issue at the stage of enforcement of an award. A party could, I do not know whether it would do it successfully or not, but a party could argue that I am not comfortable with a virtual hearing, and at the outset I never consented to this, and the tribunal went ahead with this, and as a result I have not been able to present my case in the manner that I wanted to. So I think those are some practical challenges that we will have to deal with. I'm hoping we'll have some guidance from courts soon. I mean, I'm hoping, like, an issue like this will reach court, maybe in a month or two, where some party who wants to delay proceedings is not interested and does not give consent. And that issue, I expect courts to decide very soon, and obviously expect them to decide in a manner which which is going to be pro arbitration, pro VC, because that is the need of the hour. So that's where the power comes from. We already have one decision of Delhi High Court, I think maybe 10 days ago or a week ago, Bansal Infratech Synergies versus Gale, where they've already given a time extension under 29A. So the party had exhausted both the first leg of 6 months and the second leg of 6 months, but owing to this pandemic, a time extension has already been given to conclude the proceedings. I mean, this is one issue which will impact a lot of arbitration. So on that, we have clarity that the courts are going to give us time to complete the proceedings, and it's not going to end at a 12 plus 6 months time schedule. Because I talked about written advocacy, I think I should mention here that we're expecting that either there would be a legislation from the center on some on crystallizing issues with respect to a VC. What should be the rules, what should be the procedure? But even otherwise, I mean, currently in CPC for commercial disputes, we have Order 18, Rule 2, Sub Rule 3A, where it's mandatory that prior to an oral hearing, written submissions have to be pre-hearing. Written submissions have to be submitted. So I think just along those lines, we will either see some amendments in our Arbitration Act, either in the form of a schedule as guidelines for a VC hearing, or maybe incorporated in the substantive body of the Act in respect of all of these issues. Now, I think one important aspect which everyone is talking about and is relevant is going to be, it might sound unimportant, but I think it is actually the most important step for having a virtual hearing without too many hiccups. And I think that would be planning. So from the smallest of things, and I was reading an article today, it's a part of the guidance note issued by ICC, from small things like deciding how you want the background of your lead counsel to look like. I mean, do you want it? I mean, someone might be doing it from their home, from which doesn't have a very formal background, and is probably not very professional. So I think steps like that will have to be planned. That what attire, what would be the most suitable attire. I mean, we'll have to presume that we're still going to court, in court, and properly attired. the background, what is it that you want it to be. In terms of audio VC facility, there'll have to be testing of, who are the speakers going to be, who's going to be the lead counsel amongst the entire team of lawyers. How do you if lawyers on a particular side of the case want to discuss something while a hearing is going on, how is that going to happen? I think Zoom has a feature of a breakout room. I'm not sure whether it has been used as yet. I was listening to a talk by Gary Bond. I think it's on SIAC website, and he mentioned that, although these Zoom has a feature for a breakout room, he's also not sure whether someone's used it. But I'm expecting that, I think even the technology will step up, will customize itself more to legal requirements, to how we will function, in a courtroom effectively. So, what is it that is on my screen? What is it that is on a judge's screen? What is it that is on a witness's screen? I think all of these things, technology, all of these virtual hearing softwares and companies, I think we'll see more streamlining in coming 2-3 months on all these fronts. Supreme Court and High Court in Delhi, I think, are using a facility called Video, VIDYO. I haven't used it myself, but I'm told that, that has its own benefits in terms of aiding a virtual court hearing. So on the technology front, I think a lot of work needs to be done and is happening. On what we can do as counsel, as arbitrators, would be to plan better, to sort of to make sure that everything goes electronic. I mean, I think over the last few years, in most matters that I have been doing, everything is being filed electronically. It is indexed properly. It is hyperlinked. There is an OCR search facility available. But I think all of that is just going to get more tech savvy. I think, I expect every arbitrator now to become extremely hands-on with how to use the technology, instead of us carrying bundles and bundles of papers into a room and to then, sift through those bundles and bundles and find the document that we're looking for. So organizing bundles for a hearing is going to become more and more common, to identify which are the documents you're going to rely on specifically at a particular hearing, to let those bundles be available to everyone, to the tribunal, to and to sort of not take anyone by surprise, because I do not know whether any of these VC modes today offer a system where if I wanted to hand over a document, like we do in court. So if I want to show a document while I'm arguing, which is not a part of the bundles, it's on record, but not a part of the bundles, I don't know whether that feature exists. I have read that some people are sort of a bit apprehensive about that feature not being there, because we are used to, showing documents in that manner. But I think it's just going to make us realize that the preparation levels will need to increase. We'll have to be more prepared, better prepared. Judgment compilations will need to be ready, will need to be handed over to courts. There was a lecture I was attending by Justice Gautam Patel, and there was Mr. Darius Khambata in that, and they said, I think the age and era of trying to take the other side by surprise or ambush them into citing an authority, that you've not given to them before, I think those days are almost sort of over. So this particular challenge of a virtual hearing, which we are all adapting to, will just help us get rid of all that clutter and all that unnecessary stuff that I think we have been used to and we have not been able to get rid of so far. Coming to evidence issues, I think there is good. Ayush mentioned to me when we spoke about this webinar that he had concerns as to how evidence is going to be recorded during these virtual hearings. I think it's a fair concern. It's a fair concern because one wants to be sure that the oral testimony of the witness is his own, is not being influenced by anyone either sitting with him in a room, or through maybe a separate chat box, someone sending him messages. So I think I don't know what is the answer to that, but yes, I mean, like I was reading ICC guidance note, it says that we'll have to ensure that a witness sits in a room with a desk or a lectern, if he wants to stand, and there should perhaps be a 360-degree view of the room that he is sitting in. Everyone should, while a witness is deposing, everyone should have a view of the screen which is in front of him. So if he's looking at a computer or an iPad, I should be able to see what he's looking at. If he's looking at a notebook or a book, I should be able to look at that. So I think those kind of things are being talked about, and will be dealt with in a manner that that can help us take care of this. I think another thing which is being discussed is for witnesses. I think maybe instead of telling witnesses to participate, I don't know whether it will be very feasible to expect to ask a witness to make himself available in person, maybe to go to a witness room, a designated witness room in a court, and depose from there, where there can be better supervision from court staff, to make sure that the witness is not cheating on his deposition, to put it loosely. But again, I think that might have its own challenges. I mean, assume a witness who's 60 years old or older, and is diabetic and is a hypertension patient. I don't know what is the likelihood of those people either volunteering to go to such a witness room, or whether it would even be advisable to do that. So I think but it might sound like it's going to be a very big deal, but honestly, I think all of these are small planning steps. If we do well, I think we can get there. I mean, I think we can get to a point where we'll be able to ensure, where a tribunal will be able to ensure that the deposition of a witness which was recorded is not tainted, and he has not consulted anyone while he was deposing, provided we have a system in place. We have a system in place in terms of protocols that are going to be followed, and we have a system in place in terms of ensuring that that all of that is followed. Like I said, if it means that courtrooms, every district complex, court complex, every high court will have designated rooms where people can come and use the VC facility, and probably keep a few rooms for witnesses, where it would be easier to implement those protocols. You will have someone who will know what is to be done when Mr. X walks into that room and wants to depose. So I think we'll get there is what I think. In terms of making hearings more efficient, again, I think 2-3 points which I'm going to say are not something that are specific to the current situation. I think tribunals, in foreign seated tribunals, as well as those administered by institutional by institutional setups, are already doing it. So I think it's about time that every matter tribunals will start pushing parties to be more organized, to be more prepared, to sift the evidence, sift the issues in advance, to actually explore whether you can do a documents alone arbitration. I know that in India, even when it can be done, a lot of parties are hesitant or don't approach it that way, and the tribunals don't push them too hard, because there is always this worry whether the award will be challenged and set aside on that ground, that a party was not given an opportunity. But I think if we're going to do these virtual hearings, and I don't think anyone's interested in wasting any time, in prolonging these virtual hearings, I think we'll have to structure a system in place where parties should be burdened to explain as to why do you need oral evidence in your case. What is the exact issue? Please identify the exact issue on which you want oral testimony. So streamlining those issues, those disputed points, that the two parties should, just like how issues are framed, but not the broader issues as we understand. I think the issues should be identified jointly between the parties, issues which can be resolved. Often parties can sit together and try and sort of try and sort of sift and figure out that, okay, I don't want to waste time, evidence on time and money on a particular issue. So let me get that out of the picture. Joint expert reports, again, something which is done internationally, but not so far in India. I think another concept which I see, is going to pick up result, owing to the virtual hearings that we're all going to get used to. I think all of this is just going to cut through a lot of unnecessary maze, unnecessary procedural bits that we go through for every arbitration, wherein actually it may not be required for every arbitration. So there must be now a more detailed scrutiny of, do I actually need oral evidence? Do I need expert evidence? Do I need a site inspection? If a site inspection in the current scenario, how do we go about it? Should we have a joint site inspection and, a joint report by, if the parties have an expert, by an expert, or by parties' representatives, a joint report, on what are the points of agreement and what are the points of disagreement, so that when you go to trial, it's a very focused trial and it's not a trial where you're opening up everything. I think another important aspect, today, again, I think oral testimonies are, in my personal view, and I do a fair bit of trial work in arbitrations as well as court. I think at least in arbitrations, the oral depositions are often very lengthy. The oral depositions are often not even relied upon as much as they should be, during final arguments. And most importantly, I think there is a lot of cross-examination on contents of a document. I think tribunals, this is where the tribunals will have to step in and be more stern about where they're going to allow oral evidence on contents of a document. There are very limited circumstances allowed by Evidence Act where you can do that, and curtail all of the rest, because we're not going to have the time, the bandwidth, the energy. And it's effectively, for the client, it's an issue of cost. All of that evidence, which takes days and days to get over, eventually is not even used. Often tribunals say that parties use only 1 or 2% of those 1,000 questions that you ask. Then, who's going to bear the cost for all the hearings which took place as a result of that? So I think those are things that courts, that arbitral tribunals will have to sort of be more proactive about. I think another proactive step which we can take as lawyers would be to try and see whether hearings can be divided, and whether an option of a partial award can be explored, either based on an admission, like a judgment on admissions, or often, issues of liability and quantum, if they can be segregated. If there is no need of oral evidence on an issue of liability, and it is purely based on the pleadings which have been filed and the documents which have been filed, there is no reason why the issue of liability cannot be decided first. And often, once an issue of liability is decided in favor of one party, the party who's lost the issue of liability may sort of have the good sort of wisdom to not pursue the arbitration further on the issue of quantum. it would depend on the findings in the award, but that is one way a party can do a risk assessment for itself, that does it really want to now contest the issue on quantum when it's lost on liability. I think that is one situation where lawyers can play a proactive role, and suggest this to tribunals to take it to trial in a manner that a liability issue be decided first, and not and that the liability and it's not possible in every case. I must clarify that in there'll be very few cases where you will be able to ask a tribunal to decide the liability issue before the evidence is led, or where possibly no oral evidence is being led. But I think those are important aspects where you can help your clients cut cost, and sort of save a lot of time for everyone involved. I think I've already talked about e-bundles and e-copies. I think it's not going to be sufficient to just scan documents, give them random names, and upload them on a system. I don't think that's going to be helpful. There will have to be proper protocols in place to index the documents, to put them in subfolders, to number them chronologically. I think all of those things are important, because you don't want to waste time looking for that document through the sea of documents. I think nobody is interested in that. So I think protocols must be put in place in terms of how you're going to name a file, and how must it be filed in a particular folder. All of those things, hyperlinking, OCR search, all those things. It might sound like a small thing, but trust me, it's not. When you're sitting through a hearing, looking for a document, if it's indexed properly, you know exactly where to go find it. But if it's not indexed, you will only sort of do a random search in your computer, hoping that something will pop up on your screen. Another way of sort of making these virtual hearings more efficient would be that I think instead of a bare bone list of dates, like what you've seen in is filed in cases in courts and even arbitration, I think the chronology of events, instead of calling it a list of dates, I would call it a chronology of events. I think it should be more meaty, it should be more detailed. And I think the parties should explore an option of actually filing a jointly agreed version of chronology of dates. I don't see any reason why that can't be done. The fact that an event took place, I think, in most cases may not be disputed. If it is disputed, it could have a note, in the list of dates that it's disputed by X and not, or Y or whatever it is. But I think it's important that we reduce the work of the tribunal to not have to go through, both sides counsel need not take the tribunal through a list of dates again on their turn. I think that's a humongous waste of time. And if we can agree to an agreed chronology of events, which I think is very doable, I think it will save us a lot of time. Similarly, I had mentioned that a joint list of issues, that you see as being identified. For written submissions, I think one point that I want to make in respect of written submissions is not to sort of just put together it's not just a duplication of pleadings. I think a written submission, again, it's time that we must follow world standards, best practices in terms of doing those written submissions, which means that you weave it like a story with the entire evidence. And it does not mean that you will not deal with the other side's case, because effectively then you're only arguing your claim based on what you believe is your claim without dealing with the defense of the other side. So I think that is not what the judges expect when they read a written submission. A written submission is expected to be a wholesome document, an all-encompassing document, where you lay out what is your case, what is it that you have proved, what is it that has not been disproved, and what is it that the other side has argued, and how has that been proved or disproved. I think those are the things which must contain in the written submissions. There is, I mean, I think these written submissions can't done into 200 pages, 500 pages. I think there'll have to be some guidance on what is the uh, what should be an ideal number of pages. I don't think we can put all cases in one box and say that okay, for all cases you follow 50 page page limit. But I think the idea being that these will have to be very crisp, that every word, every comma, every full stop should have a meaning, should be relevant, and it should not be something which was not needed. I think that is how I would put it. um when we talk about virtual hearings, I think we're looking at a scenario where the tribunal members also may not be sitting together in one place. So if it's a tribunal of three members, the three of them could be sitting at different locations in their own homes or offices. And I think that will include some administrative work. I will not call it challenge, but again, administrative work and protocols in place to how small things like to make sure that an award can be signed in counterparts. Those are things that a tribunal can take care of in its procedural order itself, that orders can be signed by the, like they do always, that the order can be signed by the presiding arbitrator. um, I think another positive that I see from this situation. I mean, there are few that one can see right now, I guess, but one positive that I see is that I think it will help. It will help give a boost to institutional arbitration in India, and I think they will have to come up to speed to be able to deal with a virtual hearing, because there is no way that an ad hoc tribunal will be able to deal with it without at least one lawyer from both sides spending hours and hours of work in coordinating and doing a lot of administrative work. So I think for which eventually the clients will end up bearing the cost, and I don't think it's a cost efficient way. So I think already after the 2015 and 2019 amendments, the mandate of the legislature is to promote institutional arbitration. But I see that the mode of the hearing today now gearing up for a virtual hearing, I think it's an opportunity for domestic institutions in India to lap it up and to just be ready with rooms and facilities. Like, I don't see any reason why, if I call an MCIA or an NPAC in Delhi today and say that I have a hearing today, can you send someone, set up the system at my place, and give me A, B, C, D, E? I think I see that happening. I think I think if someone wants to explore it as a business opportunity, I think it's a good opportunity for institutions to revive and get into the game of arbitration, which I think they've been lacking at effectively. um I think on there will have to be protocols, and again, like I said, it's going to be planning. So a lot of protocols and procedures in place about that recording, like I think the hearing proceedings, whether they will be recorded, not recorded, those things, that there should be no unofficial recording of the hearings. um ICC suggests some cyber protocols, so I think in terms of data privacy and security, those are aspects which also will be discussed, I think, in coming days. There are going to be smaller procedural issues, and even the smallest one will require consideration. For instance, if you have a multi-jurisdictional matter that you're working on, and you have lawyers from different jurisdictions, you have arbitrators from either one or more jurisdictions, you have witness from a different country, to match their time zones, to match everyone's availability. I think there are going to be challenges, but but it will be important to address those, because again, you don't want someone to come back tomorrow and say that I'm not happy with this award because the hearings took place when it was bedtime in my country and I could not effectively participate and address submission. So I think small things like fixing time zones, like different time zones in fixing hearing dates. What is the start time going to be? What is the finish time going to be? How many breaks are you going to allow? What is the length of each hearing going to be? Who's going to open? How are you going to identify the parties? How are you going to identify the witness? Keeping the testimony intact. This will also be an opportunity for real-time transcription to actually take off in India. I think I do not know how effective stenographers would be in a virtual hearing when I mean, unless he's told that okay, you only take down a dictation from an arbitrator, or you only take down question and answers from the counsel and the witness. I think given that it's a virtual hearing, there are going to be, assume, different at least 10 to 15 people participating in a hearing. Someone There are going to be technical glitches at someone's end or the other. So in order to ensure sort of some sanctity of the entire proceeding, there must be a record, both in video and I think a transcription form. So I see that this is an opportunity for real-time transcription to also take off in India. We've talked about breakout room options, technical issues, identifying parties. Again, etiquettes. I mean, like I said, what are you wearing? Who is going to speak? That there should be no interruption, no two people speaking at the same time. A protocol in place that yes, Mr. X is going to start, then Mr. Y will speak, and all of those things will have to be put, on a piece of paper for everyone to know in advance, so that they read it, they familiarize themselves with it, and that they follow it. I think largely I'm just trying to see if there's anything else that no, I think broadly, I think I have covered most of the concerns and most of the points that I have. Ayush, I think if there are questions from the viewers, I think I overshot my time. I'm sorry about that.
No issues. It was a really fruitful discussion, I would say. So we have a couple of questions from the viewers. The first one being that we have it from Akshansh. So he has asked that how would you say e-arbitrations would fare on on the average time consumed in an entire arbitration, as well as in terms of costs of arbitration to be borne by parties? So this is the first question that we have received, and
I assume what you're asking me is that in a virtual hearing, how much cheaper and how much faster is it going to be? Is that really your question? Like I said, it would, if it would require a lot of planning, and if that planning is executed, it will definitely result in reducing humongous costs and reducing time. So, in often, these arbitrations are, not every arbitration is going to be in the same city as you are. So, your travel, the entire travel cost of your legal team, food, travel, lodging, everything, hotel, that's a lot of money that you're saving. I mean, you don't have to serve tea, coffee, lunch to anybody during a hearing. So imagine, I mean, it's a lot of, I think it's a lot of money which is going to be saved. But again, if we don't plan it well, if we do it with a lackadaisical approach, it might save money, but it might not save time. Like if we don't try and be very disciplined about it in terms of the outcome that we want to achieve. It might save you the trouble of traveling to a city, another city, or to sort of having to waste some more time, but it may not give you an effective output in terms of a proceeding.
So we have another pretty lengthy question from Aditya. So
Okay.
he has asked, let's say in a worst case scenario, the lockdown is extended. So if the arbitration has reached an important stage of taking expert assistance, I mean expert opinion and evidence under Section 27 of the Arbitration Act, how would you tackle this situation using the virtual hearing setup?
I'm
Also,
s- I'm sorry. Is it written somewhere? Can I
yes,
read
ma'am.
it?
Yes, ma'am. It's in the group
Where?
chat. You can open the chat box, which is there in your screen. I mean, as we are
Chat. Okay.
yeah,
Okay. So
you'll
this
find the
is
section.
from Aditya, right? Is this from Aditya? Yeah, okay. So let's see, in a worst case scenario, the lockdown is extended, and if the arbitration has reached an important stage, and if the additional evidence, then how is this issue tackled through a virtual hearing setup? Do we need to apply for court assistance or some other quicker means? I think you can go ahead. I mean, if you had already filed, if you had already filed the expert report, and it was at the stage of the expert coming into and deposing in a witness box, I think you can very well go ahead with it. If it was at a stage where the expert has not yet filed his report, again, he can very well file his report. I mean, it's the question is about the documents, etc., being available, and as long as that is there, I don't see this impacting the proceeding in any manner. Ayush?
Yes, ma'am.
Yes.
So there is another question from Prakhar. In case wherein a dispute has happened during the COVID-19, how will the issue of place of arbitration will be dealt with if the same were to happen online? So the seat of arbitration, basically. How do we?
I I think that will continue to be what is in the agreement. Because the venue can always change, the seat, place, all of that is in your agreement. So I don't think any of that changes. Even today, I mean, even prior to COVID-19, there have been virtual hearings which have been happening, and your seat is not, and place of arbitration is not dependent on where you hold your hearing. That's strictly the venue.
Okay, now we have another one from Ayushi. It's virtual arbitration is much about infrastructural convenience and strength. It requires massive overhaul of the IT infrastructure. Unlike South Korea, Hong Kong, and Paris, Indian IT industry is not that efficient yet. So, has this pandemic
I, I I've read the question. I can answer that. See,
Mhm.
I mean, firstly, I'm not like very sort of I'm tech savvy. IT infrastructure, I don't know, but as I see, I think there is, I mean, I don't see anything lacking in terms of infrastructure. Honestly, bandwidth could be an issue, yes, because bandwidth in different cities could be different. We have sort of 4G and the highest broadband speeds in the metros. But if you have a lawyer or a party, who's probably on a holiday, not in a holiday, but is, let's say, on a in a place where the broadband speed is not high enough, that might be an issue. But I don't see that as like an IT infrastructure issue. I I think the IT infrastructure in India is great. I mean, we're doing it for everyone in the world. So really, I'm not sure what do you mean when you say that the Indian IT infrastructure is not as robust. I mean, maybe if you can tell me what is not robust, and if I can address that, I will answer that.
Now, I have one question of my own, ma'am. So,
Okay.
due to these, if let's say if we go completely digital in terms of the arbitration proceedings, so do you believe that it will create a great impact on the young lawyers who are stepping into the arbitration arena? Because the younger ones gain their experience, learn certain things by visiting courts, by visiting hearings and arbitration proceedings and things like that. So if that learning is stopped and if things go virtual, then number one, will it impact the learning of the junior lawyers who are, getting into arbitrations? And number two, will it also impact the number of jobs that are being created due to the proceedings in courts and arbitrations that take place?
Okay. First question first. See, we're talking about currently we're all in a lockdown where, the last time we went to our office and like we didn't know that there's really going to be a lockdown. So in terms of that, today whatever work we're doing from our homes, our juniors, our staff, there's no sort of interaction with them. But I think as things open up and we're going to have virtual hearings, the scenario that I see is that, for instance, I will be in my office and my juniors will be with me in my office. The other lawyers will be in their office. The arbitrator is going to be in their office. If I am briefing a senior lawyer, I will probably be in the senior's office, and the team, or our team, is going to be in that office. So I don't see this as a situation where 10 people on a team are going to be in 10 different places. So, in that sense, I don't think it will impact the juniors learning so much in that sense. Till the time the courts open, maybe yes, but the way I would say is it's all about adapting, right? I mean, I sort of read judgments from books. You guys have read it on SCC and Google and Indian Qanun. So, there's always going to be an upgrade to a technology which we'll adapt to. So the second question which you asked me, impact on jobs. See, I think the impact on jobs really would come from a different angle, which is that as long as the lockdown continues, there is, if people are not making enough money, they will not take on more resources. So that impact, yes, but a hearing going virtual. So if you ask me whether, I will sort of recruit less juniors if we go on a virtual mode, I don't think so. No, I see no reason. But if the lockdown continues for 6 months, and will people during that 6 months not employ more people, maybe lay off some people, maybe the answer to that is yes.
Great, ma'am. So I don't see any more questions from the viewers. So if anybody else has any questions, they can just write an email to us at info@lawspot.com. We can.
Sorry. Another thing, Ayush, I think when you said juniors learning getting impacted, I think the courts are going to eventually, they will eventually have to do live streaming of proceedings. So, so you can watch everything that is happening. So you don't miss out on anything. Okay. Yes, you miss out the feel of a courtroom, but you don't miss out on the substance. So I think, yeah, that's that from my side.
Thank you so much, ma'am. It was a great session.
Thank you. Thank you, Ayush. Thank you for this session. Thank you.
I believe if anybody else has any questions, we'll mail it to you and you can respond if you have time and if you are.
Sure.
So thank you, everyone. It was a great session from ma'am. And if you have any questions, you can mail it to us. We'll ask ma'am. Thank you.
Bye.
Thank you.